When someone is charged with a crime, they have the legal right to defend themselves. And in practice, that doesn't mean they would defend themselves. They would get a lawyer to defend them. But in practice, what it means is that a criminal defense is a legal response to a criminal charge. In the context of that legal response to a criminal charge, the prosecutor has the burden of proof to prove that the defendant is guilty beyond a reasonable doubt. That's the standard that is used by juries to decide whether or not the prosecution has provided enough evidence for conviction. While the prosecutor is going to be producing evidence to prove that a person is guilty of the crime, the defense will try and undermine the prosecutor's proof and introduce reasonable doubt regarding one or more elements of the crime. This takes us back to ideas that you should remember when we talked about mens rea and actus reus, particularly the idea of mens rea and intent. Let's see how that occurs. Defenses fall into two broad categories. The first category of rejection of criminal wrongdoing is to deny some or all of the elements of the crime. To say, well, I did X, but it didn't cause the death. Therefore, I can't be charged with a crime. And we spoke about this when we talk about the elements of the crime. An example of absolute denial would be when somebody produces an alibi, for example, and says, I didn't do it, and I can prove that by saying I was in another place at another time, and I've got all these witnesses to prove it. The vast majority of defenses are denials of wrongdoing in some or all of the elements of the crime. Paradoxically, although most defenses are based on a denial of wrongdoing, whether it's the absolute denial or denial of some or all of the elements of the crime, in practice, the discussion of defenses tends to focus disproportionately on a minority defense, a defense that's only used in a small number of cases. It's called an affirmative defense. And what an affirmative defense does is it recognizes that the person has committed the act or the wrongful act, but it says that they have a legally acceptable explanation in mitigation. In other words, they're saying, I did the act, but I'm not legally culpable. They are making a distinction between actus reus and mens rea. To be clear, for those who go to trial, the majority do not use an affirmative defense. And if a defendant is going to use the affirmative defense, they typically have the burden of proof to use it. It also is the case that even if somebody has no intent or no mens rea, it does not guarantee that they will always get a not guilty verdict. And that's for a whole set of reasons. Now, there are a number of different kinds of self-defenses. The first kind is probably the one that we're most familiar with, which is the idea of self-defense. This was a defense that was given, for example, by George Zimmerman when he claimed that Trayvon Martin was threatening him. And in this context, a person is saying, yes, I killed the person, but it was to defend myself. Therefore, it was legally legitimate. I was allowed to do that. And self-defense is going to be more broadly or narrowly facilitated depending on the particular statute, as well as certain other issues. So, for example, in Zimmerman's case, he could use the very broad definition of stand your ground laws to protect himself and argue that it was self-defense. In contrast, some statutes are much more limiting in how self-defense can be used and say, for example, that if you can safely leave an area, you cannot use self-defense. The next category of affirmative defense is something called entrapment, and it's also something that is widely misunderstood, almost to the point where we might want to consider it a myth in the criminal justice system. But it is a real defense. It just can't be used very easily or very often. Entrapment is the idea that a law enforcement officer or some other government agent got you to do something that was violating criminal law when you otherwise would not have done it. So simply accepting the offer to do something illegal by an undercover police officer does not entitle to use the entrapment defense. If somebody is an undercover police officer and works as a prostitute and solicits a client and he accepts, he cannot then say, I was trapped, because it was a case of a willing buyer, willing seller, where from the buyer's perspective, the disadvantage he has is that he was trying to buy something illegal that he shouldn't have been trying to buy from a law enforcement officer. We might ask ourselves, what about if we commit a crime because we have to? You see examples of this, say, when there are natural disasters like Hurricane Katrina. While some people broke into stores to steal TV sets, some people broke into stores to get water or medicine or food. Typically, that would be accepted as a necessity defense, because courts realized that although there was the act of, say, breaking and entering, there was no criminal intent. A similar but not identical defense is the defense of duress or coercion. This is the idea that somebody was forced into committing a crime they would not otherwise have done. So if somebody says, the only reason I committed that crime is because I had a gun pointing in the back of into my back, and if I didn't commit the crime, I was told I would be shot, that would be an example of an affirmative defense of the duress kind. It is also true that courts will often accept a mistake of fact as opposed to a mistake of law, which falls into a different category, a mistake of fact as a possible defense. So, for example, say I live in Virginia where marijuana is not legal, and I try and buy some marijuana from somebody. Maybe I'm at the Ballston Mall and somebody offers me some marijuana, so I go and get some. I say, yes, thanks, how much is it? And I pay and whatever. And actually, I've been conned. Instead of giving me marijuana, what they have given me is a herb, maybe marjoram or oregano or something like that. I actually cannot be found guilty of buying marijuana. Now, it is possible I could be charged under various other offenses, but where I actually did not do something that I thought I did wrong, typically that would be a mistake of fact defense. After self-defense, I suspect for most of us, the most common kind of affirmative defense we think about has to do with the broad category we call diminished capacity. Now, one form of diminished capacity is intoxication or drunkenness. Historically, that used to be something the courts made allowances for, but now, if anything, the opposite might be true. Say, if somebody says, well, I wouldn't have done it if I wasn't drunk, and what they did was drive their car, it's going to make their offense much worse. Another way we see diminished capacity emerging is when somebody is very young, and that fits in very much into what you're going to be learning about the juvenile justice system, because immaturity, the inability of people to fully get to the point where they can make mature decisions, is something that the courts increasingly have recognized does diminish the capacity. It doesn't mean that there might not be any criminal liability. That's part of where the juvenile justice system comes in, where people are punished for offenses that they have committed as juveniles. However, they might be punished less in all sorts of ways because of their immaturity. Another arena of diminished capacity is developmental disability. I want you to listen to this clip from a very famous novel called A Lesson Before Dying. One of the things you'll hear in this clip is that it is really an argument that the defense counsel is making about developmental disability. The defense counsel is saying, look, my client does not have the intellectual capacity to plan for a crime, to plan a crime, to intend a crime, to carry out a crime. And even if he carried it out by the influence of other people where he did not have the intellectual capacity in order to make this defense. Now, you'll also hear in this clip the blunt racism of Mississippi in the 1940s and the diminishment of the humanity of the young man who's the client. And I really urge you to read this wonderful novel. This clip comes from right at the beginning of the novel, so the story is not ruined by what you've heard, but it does capture beautifully the idea of developmental disability.
Gentlemen of the jury, I ask you to look at my client. Ask yourselves, is that a man you see sitting there? Do you see anyone who could plan a murder? Would you call this a man? A fool, perhaps, a fool who is not aware of right and wrong. A fool who stood by and watched this happen, not having the sense to run. No, gentlemen, not a man. What you see there is the thing that acts on command, a thing to hold the handle of a plow, to chop your wood and pull your corn, but not a thing capable of planning a robbery or a murder. Gentlemen of the jury, who would be hurt if you took this life? If you convicted this boy, who would be hurt? Look back at that last row. That woman you see there has been everything to him. Mama, grandmother, godmother. Look at her, gentlemen. Now, we may not see him as much, but he is her reason for existence. Think on that, gentlemen. And for God's sake, be merciful. He is innocent of all charges brought against him. But let us for a moment say he was not. Even so, what justice would there be to take his life? Justice, gentlemen, you might just as soon put a hog in the electric chair as this. Just a poor, dumb hog.
Last but not least, we have the insanity defense. Really, although we talk about it as the insanity defense, it's an inadequate name for a complex list of reasons by which our courts or our legislatures, it depends on the jurisdictions, have come to say, if a person does not have control over their brains, in part or in full, because of a mental illness, especially certain very serious mental illnesses that can profoundly distort one's understandings or one's actions, they may not be guilty for crimes. The insanity defense is a good example of one of the frequent myths we hear about the criminal justice system, because most of us think the insanity defense is used very often and used very easily and successfully. In practice, it is not used easily or successfully most of the time. It is used only in rare cases, and even in the cases in which it is used, it is more often than not successful. That doesn't mean it's not sometimes successful. And the real debate, arguably, should be, does it have a place? Insofar as criminal law recognizes that we cannot be responsible for things that we do not intend in some conscious, aware way, arguably, certain terrible acts should be exempt under this idea of mens rea from criminal culpability. However, some states have defined new categories like being convicted as guilty but mentally ill that would allow courts to recognize that somebody does have a serious mental illness, maybe even a very serious mental illness that shaped their criminal behavior, but they can still be punished for that behavior. A very tragic example that illustrates the different ways we can see how severe mental illness, which really is a much better term than insanity, might shape how juries understand crimes occurred in the truly horrendous case of Andrea Yates in Texas. Andrea Yates was a mother of 5 children and a devout Christian conservative who also had very, very severe mental illness, manifesting in part in severe postpartum depression that some of her medical team described as the worst they'd ever seen in their life. And at one point, she murdered all 5 children of hers and then claimed the insanity defense. What happened afterwards is really illustrative of the different ways we can look at serious mental illness. She had a trial, and in that trial, the state readily conceded that she had very severe mental illness. However, they said the fact that when she called the police, because she called the police and she said, "I've done a terrible thing," showed that she had the mens rea to commit the crime. The state, however, played down something that would become important later. When she called the police, as well as saying she did a terrible thing, she also said she did a very good thing. She saved her children's souls by delivering them to Jesus because they were no longer in her hands, but in his. After her conviction, she was sentenced to life in prison without the possibility of her parole, but her case was appealed, and a second jury, in a second hearing of this case, focused on the second part of that phone call to the police as proof that she did not have the mens rea to commit murder. So we can see in that case, in the first situation, she was convicted because she recognized what she had done was wrong. In the second case, she was acquitted not because she didn't kill her children, but because she was so mentally ill, she believed it was a good thing to do and that she was somehow protecting or helping her children. That example also illustrates the fact that, contrary to the myth, affirmative defenses, and in particular what we call the insanity defense, is not an easy or readily used defense in our criminal justice system.